I want to start off by briefly setting out the main point I'm trying to make with this presentation today. Since 2017, with the release of the Communal Land Tenure Bill, we have been waiting for a long-promised law that will deal with the many challenges faced by people and communities entitled to protection of their insecure tenure rights as required by Section 25(6) of the Constitution. However, unfortunately, previous, current, and future laws and policies that the state has either adopted or is proposing, including the Communal Land Tenure Bill, create legislative frameworks that fail to take into account the fact that as a result of either the lack of comprehensive frameworks that actually give effect to Section 25(6) and 25(9) of the Constitution, or the lack of political will or competence to implement laws that do exist that attempt to provide even some protection to these rights, for example, the Interim Protection of Informal Land Rights Act, or the operation of valid laws such as the Mineral and Petroleum Resources Development Act or the Upgrading of Land Tenure Rights Act. Communities across the country in the former homelands have been and continue to be dispossessed of their land and resources in violation of Section 25(6) of the Constitution, or they face imminent and present threats of dispossession that will likely result in them losing their land. By not even engaging with this undeniable and continuing reality, these proposed laws, as a result, do not provide people who have lost their land and resources any recourse or remedy for the unlawful dispossession of their land. What is particularly worrying and dangerous is that it does not even seem that this is on the radar of lawmakers or officials. There is an assumption that once a version of the Communal Land Tenure Bill is adopted, then the state will largely have completely complied with its obligations in terms of Section 25(9). Whatever the version of the Communal Land Tenure Bill does get adopted, the current and previous versions show that it will unlikely deal with the situation I've set out. And there seems to be no apparent discourse to at least consider adopting a law aimed solely at undoing the injustices of dispossession that have continued well into our democracy. For example, when civil society and affected communities made submissions to the Portfolio Committee about the impact of the operation of certain provisions of ULTRA, what those provisions of ULTRA have had on communities during the public hearing process where ULTRA was being amended, the legal opinion that followed from parliamentary officials gave the instruction to simply not deal with the offending provisions of ULTRA because the matter would be dealt with in the impending Communal Land Tenure Bill, and in the interim, communities and people would be protected by a PLAAS, and the committee was instructed to just move forward with the amendment without dealing with any of the substantive issues that were raised by communities. I'll give you a bit of a spoiler alert. People and communities are not protected by PLAAS because state officials, companies, and private individuals act as though a PLAAS does not exist. And laws that operate in violation of a PLAAS are implemented as if it does not exist. No policy or draft law, or even CLARA that was previously declared unconstitutional, dealt with this reality and provided communities with recourse and remedies in contexts when they've already lost their land. The state continues to legislate for the regulation and protection of tenure for communities and individuals in a superficial and piecemeal approach that ultimately either fails to address the underlying threats that these rights, against these rights, which are deeply rooted in the continued impact of colonial and apartheid treatments of these rights. They also failed to address the failures and the chaos that continued in a democratic South Africa, and instead pass laws that reproduce and entrench what makes communities and individuals vulnerable to dispossession of their rights by them not being properly recognized or protected. Legislating in this way treats people that have had their land and resources taken away from them in violation of Section 25(6) as if they never had any valid rights that were unlawfully taken away in the first place. The only people being given any sort of recognition or protection by this proposed legislative framework are communities and individuals who, against all odds, were able to keep hold of their land and resources until a law was passed 28 years too late, and that's on the assumption that we even get this law this year. So I'm going to focus on how the Communal Land Tenure Bill or state proposed laws fail to recognize the reality of continued dispossession and thus fails to provide any remedies for individuals and communities. I'm going to focus on the operation of ULTRA in the context of the experiences of the Kwatinabakubo community in KZN. But communities dispossessed by the lack of implementation of the PILRA or the unlawful implementation of the MPRDA would be in a similar circumstance. Ultra was adopted in the dying days of apartheid. It was a pre-constitutional attempt to reform the land tenure framework in which Black people were limited by the operation of the laws, policies, and practices of colonial and apartheid regimes. Ultra is a sweeping law that has way too many issues to get into today, but very simply, it took the rights framework of permits, of PTOs, of quitclaims, leases, and other occupation rights that were created and controlled in rural communities and urban townships by the state and granted to Black people, and converted them into title deeds through different procedures. It's a very simple explanation of Ultra, so please forgive that. Ultra still refers to traditional communities and as tribes in the text of it. So I'll be using the term tribe for the rest of the presentation when referring to the language that still remains in the Act. The majority of the provisions of Ultra deal with individual occupation rights granted to Black people by the state. However, one of the stated objectives of Ultra is to provide for the transfer of tribal land in full ownership to tribes. To that end, under the miscellaneous chapter in the Act, Sections 19 and 20 deal with the transfer of land to tribes. Section 19 provides that a tribe can obtain ownership of land and can dispose of that land subject to limitations provided for in subsection 2. Subsection 2 provides that a tribe cannot dispossess of its land to a person that is not a member of that tribe for a period of 10 years from the date that the Act came into operation. During that period, the tribe can only do so on the authority of consent granted by a court. To grant this consent, a court must be satisfied that the dispossession is authorized by a tribal resolution, the proposed disposal is not in conflict with the interests of the members of that tribe, and alternative land is available, and the people who live on that land have waived their occupation rights to that land. This requirement of court oversight in cases where tribal land was being disposed, expired in 2001. After that, there is no such requirement that exists. And since there is no requirement to inquire about the impact that any disposal of tribal land will have on the members of that community, or the rights, or what rights are implicated by that disposal, or whether any laws that are relevant are actually complied with. For example, in each of these contexts, does the PILRA apply? And if it does apply, has it been complied with? None of those inquiries are required by Ultra at this moment if a tribe or a traditional community, as we refer to them now, wants to dispose of land that's been transferred in terms of it. And then the question then becomes, how have these provisions operated in practice, and what has been the impact of their operation on individuals and communities that these provisions have been applied to? To illustrate how these provisions have operated, I will be referring to certain aspects of the experience of the Kwatinabakubo community in the KwaZulu-Natal. In 1983, the KZN government began negotiations for the construction of the Zenande Dam. This would result in the displacement of a number of traditional communities, including a portion of the Ngqolosi tribe. It was agreed that the South African government would provide compensation, and any compensatory land would be vested in the South African Development Trust. Land was identified from the Ngqolosi tribe, in which a portion of that land was primarily agricultural land, and a portion of the land was earmarked for urban development and was eventually developed into a township for the displaced members of the community. My focus will only be on the agricultural portion of the identified land for the community. With the dying days of apartheid, the land could no longer be transferred to the South African Development Trust. Instead, in April of 1994, the agricultural land was transferred in the name of the Ngqolosi tribe to be vested in their chief. That transfer took place in terms of Section 20 of Ultra. Since that transfer, unbeknownst to the displaced members of the community, portions of this land have been sold by the traditional authority under a power of attorney granted to chiefs to 17 individuals. Two larger remaining portions, one of those remaining portions was sold to a eThekwini municipality in 2010. The transfer deed reflects a huge amount was purportedly paid for this land. This is ostensibly to defray costs of rates and taxes, but it's not very clear exactly what happened there. In 2016, another larger portion of land was donated to a development company, and it appears that the chief is the director of that company. As I mentioned above, because of when these transactions took place, when these sales took place, and when these transfers took place, there was no requirement of judicial oversight. Even though that particular remedy is not always perfect and is not always appropriate, there was absolutely no engagement with the impact of any of the transfers would have on the impacted community. When members of the community wanted to make use of the agricultural land, they discovered the sale and transfer of their land. They tried to find out how this had happened without their knowledge or consent, but have been sent from pillar to post trying to get answers and raising concerns of corruption. They have not been able to get any clarity about the details of how and why these transfers occurred, or have not had any resolution in that regard. In trying to get some sort of remedy, they have engaged with multiple institutions, including the Public Protector, COCTA, and the Department of Rural Development in KwaZulu-Natal. During one of those dispute resolution processes, both COCTA and Rural Development were required to participate, and each had to provide reports. In any of those engagements, there's been no, neither of these departments have actually engaged in what it means for this land to have been transferred, and can provide no answers as to how it happened without the knowledge and consent of those directly affected community members. Now, with that sort of context in mind, and then we look at the current version of the Communal Land Tenure Bill. The Communal Land Tenure Bill, if it would be adopted in its current form, would repeal sections 19 and 20 of ULTRA. These are the sections that allowed this transfer of land. However, nothing in the Communal Tenure Bill will provide any remedy or recourse to communities in situations similar to that of Dinabakubu. It is not clear how many transfers of community land have happened in terms of these provision of ULTRA, and what the status of this land currently is. And I'm only just talking about ULTRA. Communities dispossessed by the unlawful operation and implementation of the MPRDA in violation of the PLAAS are still in a similar context. The Maledu judgment is a good start, but it provides no real remedy for many communities that have already been dispossessed of their land. Communities that have been dispossessed of their land as a result of the improper or lack of implementation of a PLAAS are also in a very similar situation. The Baleni judgment in relation to the Kolobeni community is also a really great judgment, but again, no real remedies are created for communities that have already been dispossessed of their land as a result of lack of government action and as a result of lack of implementation of existing legislation. So when you attempt to legislate with no real regard to the reality of the context that exists, only means that many of the communities and individuals who continue to bear the brunt of South Africa's legacy of injustice and dispossession continue to remain on their own. Thank you.